Hello. Good afternoon, I guess. My name is Jordan Walker. I am with Seaver Walker Paget Law Firm. Thanks for joining us today. As you're aware, we're going to be talking about eminent domain. We're going to be talking about the State Road 9 project today, and what has happened, what's transpired over the last several months or so. We're going to talk about that. We're going to talk about eminent domain, of course, a little bit. And with that being said, we're just going to go ahead and get started. If you do have questions, feel free to put them in the chat or ask or use the Q&A button. I might not address them now. There's a decent chance I'll answer them as we get into the presentation, but feel free to ask them as they come up. Okay, so let me share my screen real quick right here. Okay. So real quick, we like to kind of establish who we are and why we're talking to you. Why are you getting letters from us? Why did you receive this letter? You received this letter because we've identified this project specifically as a project where they're going to have to get into right of way and acquire land here again here in the next year or so, next several months, I would imagine, and so forth. So we recognize that. We read the news articles about what happened, and so we sent out letters immediately to those landowners because we believe that because of this mishap by GDOT, which we're going to get into, that they're going to be coming back out to issue new offers and acquire the land that they thought they had already acquired. Real quick, who we are. Again, my name is Jordan Walker. I am an eminent domain attorney, the law firm of Seaver Walker Paget. Our firm, this is the only thing we do. It's the only thing I do as an attorney. We only do eminent domain, and we only work for landowners. So that is, and because that's the only thing we've done, we've obviously accrued quite a bit of experience. We've learned a lot, not only in the state of Georgia, but in all the other states where we practice. We've seen it all. And so your situation, it's probably not going to be different or foreign to us, and we'll probably be able to recognize it or the pattern and the details from other cases we've worked. So we do not work with the condemner. We don't work with the Georgia Department of Transportation. We don't work with any DOT. We never have. We never will. And today, what we're going to be talking about, largely, we're going to talk about what happened with the project. We're going to talk about eminent domain. And we're going to talk about key points to recognize in your negotiations with GDOT. So let's talk about real quickly, let's talk about what happened with the state SR9 project. So SR9 project it's a large project. I think it's 15 or 20 miles or so. It's a particularly extensive project. On one portion of this project, it would seem, and this is all based on news reports that I've read, and you may have read as well, that a right-of-way agent working for the DOT essentially told the DOT that they had already acquired the land for this project, specifically from Windward Parkway in Alpharetta north to the Forsyth County line. So in that portion of the project, apparently a right-of-way agent went out. Not sure what they did with the landowners. I'm not sure if the right-of-way agent negotiated deals with the landowners or didn't even contact them at all. But what ended up happening is that this same right-of-way agent for the Georgia Department of Transportation told GDOT that they had acquired this land for this project. And as it turns out, the land had not been acquired. The deeds had not been signed. None of the land, seemingly, that was supposed to be conveyed to GDOT for this project had been conveyed in this area of the project, which I believe comprises about 133 parcels. So long and short of it, GDOT thought they acquired the land. It turns out they didn't due to a rogue right-of-way agent, allegedly. And consequently, what this all means for the landowners is that because they didn't acquire it, they need to acquire it. And they're probably going to be acquiring it quickly because the project is moving forward, and it was moving forward under this assumption. So they might do it quicker than normal. So landowners need to be prepared when they come in and start making offers. So that's what happened with SR9. So let's talk about what happens with eminent domain generally. And this is, I should say, this isn't generally. This is the procedure for all acquisitions in Georgia. But we are going to be very general about the phases. So the first phase of the process is the appraisal. And this is per law, per Georgia law, GDOT needs to appraise your property, needs to inspect the property, come up with an appraisal for the acquisition, and make an offer based on that appraisal. But the first stage of the process is the appraisal. So the appraiser will contact the landowner. They'll send a letter to the landowner informing them, I should say, informing them that they're going to come out and appraise the property. They will come out and appraise the property. And then shortly thereafter, that appraisal is done. I say usually between 1 to 3 months, you will receive an offer that is premised on that appraisal that had already been done. So they come out, they appraise the property, and then a separate person gets involved and issues an offer to the landowner. Again, usually about 1 to 3 months after the appraisal, the right-of-way agent issues the offer and negotiations begin. The offer negotiations come from the type of right-of-way agent that was doing all the bad stuff on SR9. So you'll unlikely to get that right-of-way agent. I don't think she works for GDOT anymore, or she won't. Unclear. In any event, another right-of-way agent will reach out to you, issue an offer premised on this appraisal. That's where our firm gets involved, because that's when you have an offer. That's when you have a case, and we can evaluate it, accordingly. So the appraisal has been done. You've issued an offer. What happens if a deal can't be reached with the DOT? If a deal can't be reached, then the process moves to eminent domain, and a lawsuit is filed by GDOT against the landowner in the county where the property is located. That is eminent domain. It's also referred to as condemnation. They're one and the same, and that is the condemner, the state or DOT, filing a lawsuit against you to get your property. So that's beginning to end, really. Not all cases reach eminent domain, I should state. Most of our cases don't. A lot of times we're able to get the deal done without going to court, without going into litigation. So that's good generally. But if necessary, eminent domain is available. What I tell folks about whether or not they should be in eminent domain is, and that is get to that stage of the process, is that if you are eminent domain, it's because you should want to be there. It's because GDOT is being unreasonable. They're not willing to come to work with you to get you to the compensation package you're entitled to, which happens quite a bit. But if they don't do that, then you should want to go to eminent domain, because otherwise your option is just taking what they're offering. But on the flip side of that coin, you don't want to be at eminent domain if you shouldn't be. Meaning, if your case is not particularly big, the difference in opinion is not particularly large, then those are the types of cases that you don't want to end up in eminent domain, because then you're paying attorneys, then you're paying costs for a situation you shouldn't be paying costs on, shouldn't be paying to continue on. It should be a case that is resolved earlier rather than later. So whether or not your case is one of the former or the latter, should it be in eminent domain, should it not be in eminent domain, that's ultimately going to be up to it's going to be up to you, but usually on advice of counsel. And counsel should be able to inform you and tell you about where your case should resolve pre-suit or at litigation. Here is what to do when you receive your offer. A lot of folks don't know what to do when an offer is issued, and this can be a crucial time for a landowner. It's easy to do the wrong thing. Here's what you should do. You should insist, first of all, that the right-of-way agent communicates via email only. They're going to want to call. They're going to have in-person meetings, and they do these because these are off the record. There's no one writing down what's being said, really, and they make all sorts of promises and verbal that mean nothing. A verbal promise means nothing. So they make all sorts of claims and this and that. And those claims don't mean anything if they aren't, on paper, if they're not emailed, if there isn't a documentation that they are offering this, or they're willing to do this, or they're willing to do that. Because a lot of times they'll say they're willing to do something, but they won't put it in writing. And when you say, well, what about that promise you made? They say, what promise? So to avoid any issues, to make it clear that nothing else has been said, or what's been said has been said, I would say that communicate with email only. Have them send their offer via email. If you choose to communicate with them, I would do via email as well. I'll get to whether or not you should here in a bit. Once you get your offer via email, I think a lot of people think they're under the gun. They need to respond. They need to do this. They need to do that. What I tell folks is that uh, once you get the offer from them, respond, thank you. I'll look at it. I'll review it. I'll get back to you in a week. You can have a week. You're not going to be under any sort of deadline within a week. You'll have more than a week in all likelihood, but no one's going to get mad at you for asking for a week. And that'll give you enough time to decide what you want to do, how you want to respond. And that will, I feel, is an appropriate response in these scenarios. Once you do that, contact an attorney. I'm happy to look at your offer for free, review it for free. No compensation for me for those types of reviews. Not a problem. I'll look at it and I'll give you my thoughts. You can decide what you want to do. And also something to do is to avoid, again, in-person discussions and negotiations. Verbal negotiations, verbal offers are worthless. They don't mean anything if they're not in writing. So there's no point in engaging in these types of discussions if they're not going to put what they're willing to offer verbally in writing. What not to do when you receive your offer. What I tell people, do not engage in negotiations or discuss value or the property really itself before contacting an attorney. It seems like common sense if someone issues an offer and you have to sell it to issue a counter offer. But again, if you issue these counter offers, you might be underselling your value. I've had folks that throw out a number that they think is appropriate. Well, it turns out they didn't factor in something else that they didn't consider, or they didn't know of a comp over here or this or that. I just generally don't advise to put yourself behind an 8-ball and begin negotiations on something that maybe you don't know what you're entitled to or what you should be getting. So I don't recommend getting into negotiations with right-of-way agents before you talk to an attorney. Don't enlist an appraiser. A lot of times, because they did an appraisal, landowners feel they need to do an appraisal. And sometimes landowners do need to do an appraisal. But in our view, those appraisals aren't necessary unless you're in litigation. And sometimes they aren't even necessary then. And these appraisals are expensive. The eminent domain appraisals are not cheap. They're not just like a traditional appraisal. So I don't generally advise that my clients go out and spend that money unless they absolutely need to. And in my view, they don't absolutely need to unless you're in court, unless you're in litigation. And a lot of times I'm able to get a landowner to a compensation package that they would have otherwise gotten with an appraisal, meaning, sometimes just sometimes our ability as attorneys and our ability in our to help and assist landowners, just through our ability, we can get folks to where they need to be, a compensation package, without spending the extra money to get the appraisal. So I would generally not advise getting an appraisal unless you absolutely need to, or unless an attorney tells you should. Do not meet in person with right-of-way agents. We already touched on that. Do not make a rushed decision. This is fairly common, unfortunately, landowners to ignore these situations and not address them until it's too late. This is something that it deserves your attention, at least preliminarily. An easy way to avoid all of this is to, once you get the offer, hire an attorney and let them handle it. But again, they will try to rush you into a decision when they come in and make the offer. And we, of course, usually rush decisions are bad decisions. I do not recommend jumping on anything immediately as it's proposed. And do not ignore it altogether. On the other side of that coin, there is folks that, there's people that make rush decisions. There's people that don't make any decision at all, and they let it languish and they let it sit and forget about it. And then all of a sudden you're in court because you ignored something that you should have paid attention to. This happens as well. So I don't recommend, again, just ignoring it and putting it to the side, because folks that do that usually end up in court when they shouldn't be in court. And then I want to talk about 4 keys to your case, and then we'll talk about hiring attorneys, and then we'll be done. Four keys to your case, and these apply generally to all cases, eminent domain cases. The first key to your case, and this is compensation, of course. What's the value of the property? What's the value of the taking? What are they acquiring? What's that land worth? So you have a 5-acre tract. They're taking 1 acre. What was the 5 acres worth before? What's the 1 acre worth that they're taking, and what's the 4 acres left in the after? All of these are relevant considerations in determining your just compensation. What is the value of your land? The value of the taking. What's your the value of the land before the acquisition? What's the value of the property after the acquisition? And this is all determined by examining comparable sales of property that are similar to the subject property. Uh, GDOT has a tendency to use inappropriate comparable sales. They have a tendency to use lower sales, lower comparables to try to lowball landowners. Something we've seen quite a bit, something I would look for in your case as well. The second issue, remainder damage and consequential damages. This is for partial takings only, so when they're only taking a portion of the property. And consequential damage, remainder damage, they're the same thing. Really, these terms just mean how does the acquisition impact the rest of the parcel? How does it impact the remnant, as it's referred to? So on partial takings only, a lot of times partial acquisitions can have huge impacts. For example, if an acquisition takes an access point or it limits access to the parcel, if it loses parking, if a home is closer to the road than it was previously, if trees that provided cover for a home or for a building are removed and there's no more cover from the roadway supplied by the trees, that has an impact. Loss of internal circuity, if you can't get around the parcel anymore because it's too small or it's not set up that way. Zoning compliance, if it causes the parcel to be non-compliant with zoning, that is a problem you need to deal with, not a problem for GDOT, even though they're the ones that caused it. So these are all kind of how consequential damages can reveal themselves. They're certainly not the only way that they can reveal themselves, but the long and short of it is that many times partial acquisitions have huge impacts on the entirety of the parcel, and rarely does GDOT appropriately compensate landowners for that impact. And then the final two components, business losses, and this is only for properties with businesses on them, and rentals count as businesses. And in some instances, you can get business loss recovery in the state of Georgia. This is a uniquely Georgian law that does not exist in many other states. GDOT does not offer business losses as a matter of policy, even though they are something you can recover. These can be very big depending on what type of business is impacted, and it can usually be a significant figure depending on what's happening, because GDOT is not going to offer it. So these are things that you're going to need to fight for, and you're going to need to raise your voice, because it's not something that they're going to do any favors for you. And then finally, relocation. This is for total acquisitions only. So when they're taking the residence, they're taking the business, and something needs to be moved or relocated, they will offer relocation benefits as well. They're separate from your just compensation claims that are through the first three items. So relocation can be a huge component if you are being relocated. And again, GDOT lowballs just like they do with all the other components as well. Okay, so finally, getting into hiring an attorney. I can't speak for hiring other attorneys, of course, other counsel. I can only speak on behalf of hiring our firm, but our firm operates on a contingency fee basis, which means you do not need to pay money to hire me as your attorney. Our fee is contingent on how well we do for you, how much more money we get for you than what is offered by the DOT. If you had an offer and you wanted to hire our firm, you wouldn't have to write me a check. You're not sending me money. Really, there's no money exchanged between our firm and the client until the end, because at the end, that's when the case is done, and that's when we collect our fee. So, for example, if you were offered $10,000 by GDOT and you hired our firm and we got you $100,000, our firm would take a third of the 90 that we add to the case. You get the rest, and that our fee comes out at the end, so you don't need to come out of pocket in the interim. And also a question I get a lot is, what if we don't get you any more money than what's offered by the GDOT? In that instance, then we don't collect a fee. But we are very selective in our cases. We don't just take on any old case that comes in. Um, so if we're taking on your cases because we feel good, if we feel confident in our abilities to get you more money and possibly significantly more money, and to that end, these are some examples of road acquisitions recently that we've had at our firm. And I don't want to, these are not guarantees of success. I'm not telling you that if you have a $15,000 offer that we're going to get you $3 million. That not every case is like that, obviously. But what these results are illustrative beyond how well we can do for landowners. They're illustrative of how bad offers can be, initial offers that are issued by DOTs. They are, I mean, there's a reason our firm exists, and it's not because the DOTs come in and make great offers and make high value offers to landowners. If they did that, largely our firm wouldn't be necessary. But because DOTs come in, make low offers, don't consider remainder damage, don't follow the law sometimes, don't offer business losses, relocation, etc. Because they don't do that, we have to exist. And so these are kind of illustrative of how bad it can get. So at the end of the day, though, we are, as the title suggests, we are a results-based firm. We know a lot about the law. We do this in a lot of states. We have a lot of experience, but ultimately, it doesn't really mean much if we're not able to get folks just compensation. And so at the end of the day, our grade, how we base our performance, is how well we do for clients, how much more money we get for landowners. And these, again, are illustrative of some examples where we've been able to do that. And this is my last slide. And with this, I will end the presentation. I will stick around for some questions if there are any. But moving forward, what I tell folks is that if you've been contacted on this project specifically, the schedule is going to be tighter than usual, I imagine. So they're going to be aggressive with their land acquisition, I would assume. So, but they do need to follow the law again. So they're going to come out, they're going to do the appraising. But once they start appraising, once you see the appraisers around, and once you get that letter from them notifying you the appraisal, I would say it's time to start talking to attorneys. But once you get that offer, that's when you need to hire an attorney, especially on this project, because they're going to move quick, they're going to be aggressive. Is my suspicion due to the scheduling problems. Again, don't rush. If you can get a group together, usually through neighbors that are also affected, that is also great. It's not necessary, but if you come to me with a group of 10 landowners, for example, I can potentially lower my fees to help out everybody in the group. And then finally, I'll leave you on this note. Beyond the phone number, that's my phone number, by the way, 470-869-1383, and then jordan@landownerattorneys.com. That is my email. Please don't hesitate. You can text that number as well. If you have an offer, you can text it. But the final point I will leave on before taking questions, if there are any, is that this is the only chance you have at compensation. Once the deal's been struck, once the deal's been reached, property's been conveyed, it's over. The case is over. There's no going back. There's no takebacks. Once it's signed, it's done. So I think it deserves your attention at the very least to make sure everything's right. Make sure, at least, even if you think everything's great and nothing appears to be wrong, you never know. It's always good to have peace of mind, especially because there's only one chance at this. So that's why we offer free reviews. If you're not sure, if you just want to get a second opinion, we're happy to offer it for free, of course, and you can decide what you want to do because it's too important not to. So there's one chance, and this is it. So with that, I will take any questions such that they exist. Okay, I'm not seeing any questions. So if we don't have any questions, that's fine. Well, thank you for joining me today. I appreciate it. If you think of a question later, shoot me an email, give me a call, shoot me a text. Happy to talk about it further. Otherwise, thanks for stopping by today, and good luck. Have a good day.